out, find this new evidence, and show what they would have had within 30 days. And once you miss that 30 days, there's no other, you don't get allowed to bring it again. So that's it. And it's only, the higher court will only overturn a lower court if they find the judge abused their discretion. So then you get into post-conviction, which we talked about, where you don't have a right to an attorney here, that's called your Rule 37. And the courts have considered this a collateral attack, which means you're attacking it on it being unfair, not on the face of the evidence that's in front of you. And so they have said newly discovered evidence is not appropriate in the post-conviction process in Arkansas. The courts have decided that, so we aren't allowed to raise it. And again, it must be filed here within 90 days of your judgment, or 60 days of your judgment. So again, what if that victim doesn't show up alive until 5 years later? How do you get back into court and ask them to hear this evidence? So then here's the really complicated one. So the habeas corpus here, which is new scientific evidence, this is essentially the DNA testing statute here in Arkansas. So if the evidence wasn't available at the time of trial and it would establish the actual innocence, which is often what we think of, a DNA test, right, or a rape kit, which is, that would let them out. But it has to be that it couldn't have been discovered before, has to be filed within 36 months of the conviction, and that they didn't waive an opportunity to have it. So if they could have had DNA testing at the time of their trial, and their counsel didn't request it because maybe they had poor counsel, well, you waived it. You had a shot, and you didn't use it. And this is only saying if the evidence wasn't available then. It was available, now you're not there, so now you can't have that testing. We also have, so in Arkansas, when I was talking about post-conviction or state habeas, the error quorum nobis fills that gap in the habeas, this is what's known to be in the legal system. But the courts in Arkansas have found that the error quorum nobis only applies in these 4 areas. So they will only look at it, which is insanity at the time of trial, if it was a coerced guilty plea, if there was withheld evidence that was really important, prosecutors call it a Brady violation, or, and I think this is a really fun distinction, a third-party confession to the crime that was made between the conviction and your direct appeal. So that's essentially saying in that motion for a new trial gap, so if you missed your 30 days, but now you still got another 30 days and you're trying to do your direct appeal, they'll fill that gap for you if someone comes forward and confesses. But that's it. That's all they're going to look at. They're not going to look at all this other new evidence. We're wondering if maybe that will change. There was a recent case called Pittsburgh State, and it was a microscopic hair comparison case, which is what my colleague was discussing earlier about how these analysts would testify beyond the realms of science. So in that case, they said, look, this is based on microscopic hair comparison. We want to have this new scientific evidence. We know that you're not allowed to say these things in court and bring it back. And the Arkansas Supreme Court said, well, we will give the court jurisdiction. We're going to send it back to the court to hear, say they have jurisdiction, but nobody knows how it's going to shake out or what claims that they'll be able to raise. And then here's where things get even more tricky in the Arkansas state. So we talked about federal habeas, right? And that's where people are getting exonerated. So you have 1 year to get to the court following a direct appeal. Well, when I was talking about that exception that allows you into court of innocence, that I'm actually innocent and you'll let me in when I miss that 1 year deadline, I have to have new evidence that shows that. And the 8th Circuit, which Arkansas sits in, is the only circuit that says that new evidence must not have been available at the time of trial. So, for example, if I come up, and this is a real case I've had in the 8th Circuit, I can prove who committed the crime, I have confessions from real perpetrators, I have all this other evidence, but all of it was available. I have an alibi, a videotaped alibi, all these things. All of that was available at the time of trial. And so the 8th Circuit actually said, this is the case, that even though he's innocent, because it was not, we had no new evidence, that wasn't enough to get him in the door. And since we can't get in the door, he can't win. So that's Mr. Ricky Kidd, who's still incarcerated. Because of that, they said, we don't care, there's all this evidence of innocence, but you need something new. The 8th Circuit is the only circuit in the country that does that. But when you couple that with how we've limited access to the courts in Arkansas as well, it essentially means that there are a number of people falling through the cracks. As some additional information to sort of highlight that, I have a wait list of about 600 cases in my office of folks who want their cases investigated. On that list, I have 135 individuals who have applied from the state of Arkansas. So there are 135 folks who want help, and for us, it's very difficult because I may be able to prove their innocence, but I can't get them into court. And that's why we're really grateful that folks are looking at this.